Good afternoon or morning, depending on where you are joining us from today. My name is Matt Ridings, and I'm a partner in Thompson Hine's Antitrust, Competition, and Product Distribution Practice Group. I'd like to welcome you to today's webinar. This is the third in a series of webinars targeted at issues that businesses face operating in a COVID-19 world. Our next scheduled webinar is on May 19th. Forecasting, negotiating, and closing M&A transactions during and after COVID-19. We are planning additional webinars as topics arise. To sign up for those webinars or any other, please visit our COVID-19 Task Force page. Before we begin, a few housekeeping items. First, today's program is being recorded, and we will send a link to all attendees within 48 hours of today's presentation. Second, if you have any questions during the webinar, feel free to use the question box located in the control panel on the right side of your screen to submit questions. We will answer as many of the questions as we can at the end of the webinar and will continue to remain online until 2:15. Third, we will be offering CLE credit for today's webinar. Please be sure to fill out and return the webinar affirmation form that can be found in the handout section of the control panel located on the right-hand side of your screen. The form provides instructions as to where to send the completed form. You will need a tracking code, which I will announce at the end of the program. Last, in the handout panel, you can also download a copy of the PowerPoint slides and bios of today's speakers. Again, thank you for your interest, and if you have questions as we go along, please use the question box. I'm delighted to introduce my colleagues that will be presenting today. Jeff Appelbaum, a partner in and head of the firm's construction practice. Jennifer Ellman, counsel in the firm's corporate practice and a member of Contract Solutions. Tom Fair, a partner in our business litigation practice and the firm's loss prevention partner. Tom Mason, a partner in and head of the firm's government contracts practice. And Jennifer Roach, a partner in the firm's antitrust, competition, and distribution and white-collar criminal internal investigation practice groups. And I thought we'd begin today with an introduction to force majeure and a bit of background on how force majeure clauses generally work. Force majeure clauses are clauses in commercial contracts that provide a defense to liability when a specified event occurs that's beyond the control of the parties and prevents or delays performance. Importantly, force majeure is a contractual doctrine, not a common law doctrine or a statutory law doctrine, at least in common law countries and common law jurisdictions. This means that courts will look to the language of the clause itself and the scope of the relief provided in that clause to determine whether a particular event is a force majeure. There is not a common law body of force majeure law that will excuse performance except in limited circumstances that we'll discuss later. This may seem at first blush a little bit unfair, but if you consider force majeure clauses as a bargain for allocation of risk between the parties, where the parties agree by contract to assume the risk of unforeseen or unpredictable events, then it begins to make sense. This has implications for drafting of the clauses and a declaration of a force majeure, both of which we'll talk about during this presentation today. One of the common issues that come up especially in light of the COVID-19 pandemic is, can a catch-all force majeure provision provide a defense? And we have on the screen a typical force majeure provision or a common force majeure provision that doesn't specifically mention pandemics, but has a catch-all that talks about any other clause beyond a reasonable control of the party. This is something that courts will look at and interpret according to a doctrine called ejusdem generis, which is a Latin term that essentially means the broad catch-all provision is limited in scope to the same types of events or things that are specifically enumerated in the clause itself. So in looking at our sample clause here, whether or not the pandemic is sufficiently related to a strike, an accident, an act of God, an explosion, a flood, or a fire, is something that the court would have to determine in order to decide whether or not the COVID-19 pandemic would be covered by this particular force majeure clause. And this is something that we'll also be talking about a little bit later on during this program. Finally, force majeure clauses are often referred to as clauses that deal with unforeseeable events. But in contract drafting, unforeseeability is an issue that the parties can choose to include within the contract or not choose to include within the contract. A force majeure provision can be drafted so that a particular event must be unforeseeable, or it can be drafted so that unforeseeability doesn't matter. As we continue to go forward and deal with the COVID-19 pandemic and other issues such as climate change, the foreseeability issue is something that is going to be of particular importance because, at least right now, the COVID-19 pandemic is a foreseeable risk. And so how the parties treat foreseeability within the contract will be important in determining whether or not the future pandemics or whether or not a future application of COVID-19 will be covered by force majeure. And with respect to the applicability of force majeure clauses, the Uniform Commercial Code, and common law defenses to business disruptions, I want to refer to my colleague, Jen Roach. Jen?
Thanks, Matt. There may be instances where your contract does not have a force majeure clause or a supplier hasn't yet declared force majeure. And so I'm going to talk a little bit about what you can do in those instances. After SARS, MERS, and COVID-19, it's very optimistic to think that companies won't be encountering supply chain disruptions in the future, whether it's related to pandemics, climate change, or other events. When your business is facing this type of uncertainty about the ability of your suppliers to meet your needs and their commitments, it's critical to get up-to-date knowledge to help manage your risk and to collect the relevant facts should a dispute arise. So the first thing to do is to review your contracts with key suppliers and try to proactively engage with those suppliers. Make sure that you understand the notice provisions, termination provisions, if there's exclusivity provided, and default provisions. Also take a look at your contract to see if you have a right of inspection or an audit right. At this point, if there is some uncertainty about your supplier's ability to live up to their commitments, it would be good to exercise those rights to get an understanding exactly of how the supplier is being affected so that you can manage your own risk. If you conclude that the supply is too uncertain, that the supplier is not going to have the capacity to meet your contractual commitments, you could consider sending a 2609 notice under the UCC to request adequate assurance of performance. This is definitely a little bit more of an aggressive step. It raises the stakes with the supplier. So this may not be your first choice, but it is an option available. If the supplier cannot provide the requisite assurance in 30 days, then you are permitted to treat that as a repudiation of the contract. It's a very fact-specific determination about whether you would have reasonable grounds of insecurity to ask for the assurance and whether the assurance provided is adequate. So it's another reason why it's important to gather all the facts of the situation first. Now, depending on the relationship that you have with your supplier and the importance of that relationship and how long you project it going out into the future, an option is always to renegotiate your contract to ease restrictions, to assist the supplier in meeting your needs, to provide more flexibility to you. For example, if you wanted to make an exclusive contract non-exclusive, but still preserve the relationship that you have with that supplier, But under the UCC, you can modify a contract for the sale of goods without consideration. So a negotiated resolution and modification to the contract is always a potential option. And if despite these efforts, you as a buyer are still unable to get the goods that you need because there's a severe shortage of raw materials or your supplier shut down, UCC 2615 may provide you with some relief with respect to dealing with your own customers, because it does give you the option to allocate production among your customers in any manner that's fair and reasonable, so long as you seasonably notify your customers. Again, this is a factual area and can be subject to dispute, but that option is available if you aren't able to resolve your supply issues. Next. So what are the things that you can be doing right now to try to minimize risk and plan for future supply disruptions? Companies that rely on one supplier will face bigger challenges when that supplier is affected by the next virus or climate change. So to take steps now, you want to take steps now to increase your flexibility and diversification in the event of a future disruption. One way to do that is to engage multiple suppliers in different countries and different geographic regions. Another is to avoid exclusive supplier relationships where possible, or to allow for exceptions in your contract to that exclusivity if there are extenuating circumstances. Another is to pre-qualify multiple suppliers for crucial goods so that you are easily able to transfer production to an alternate supplier. Next would be to take a look at your existing contract provisions and revise them as necessary to increase flexibility if you're talking about forms that you regularly use. The same is true if you have contracts that are coming up for renewal. You have the option to then try to renegotiate those contracts to include more flexible terms to minimize risk in the event of future supply disruptions. The provisions that you would want to take a look at are force majeure clauses, and Jennifer in a moment will talk with you about drafting those provisions. Dispute resolution provisions. Is the form that you identify in your contracts the most favorable? And that goes also for the choice of law provision in an agreement. You'll want to take a look again at notice provisions, termination rights, if you have any most favored or preferred supplier provisions, production commitments, and any provisions regarding insurance and indemnity. These can all be helpful in providing you with maximum flexibility in the future. And to help your company manage the risk of the next disruption, it's also going to be important now to keep track of the lessons that you're learning right now as you're navigating through COVID-19 and the disruptions caused by the global pandemic. Write down what's worked and what has not worked. In addition, there may be some technological solutions that can be implemented to help provide you with greater visibility into the supply chain and how it's affected by external events. And finally, one thing that you might want to consider doing if you don't have one in place already, or to revamp one that you do have in place, is a troubled vendor program. Many manufacturers develop these programs for liquidity to support critical sole source, just-in-time manufacturing processes until they can identify alternative suppliers. And there are various avenues to enhance the likelihood of repayment, including assignment of tooling and IP required to supply the product, security interest and collateral, and things of that nature. And now I will turn it over to Jennifer Ellman, who will talk about drafting of force majeure provisions.
Thank you, Jen. As Jennifer said, I'm going to be talking with you today about some drafting tips, both from the perspective of the buyer as well as the seller when you're drafting your commercial contracts. So beginning with the buyer, obviously the buyer's primary concern is going to be ensuring a continuous and uninterrupted chain of supply for the products and services it needs to service its own customers. Therefore, a buyer is going to want a force majeure clause that's narrowly drafted and does not allow the seller to avoid its contractual obligations except where it's truly warranted. Therefore, when I'm representing a buyer, the first thing I look for in my force majeure clause is the definition of or defined force majeure events. I want to review this list critically to narrow it down to those events that I think will actually prevent the seller from performing and which cannot be prevented simply by the exercise of good business practices, triggering their business continuity events, etc. So in other words, I want to make sure that the seller does not try to use the force majeure clause simply to avoid performance because the contract has become unprofitable or undesirable. So I would strike things in my clause such as an increase in the cost of raw materials, an increase in the cost of labor, and things of this nature, which should really be addressed through the commercial provisions of my contract and not through a force majeure. Next, when I'm representing a buyer, I would want to be sure to include a provision that states that my obligation as buyer to make payment for goods or services will be suspended throughout the duration of the force majeure event, even if there are committed monthly payment amounts or guaranteed buyer commitments. I would want to make sure that those were abated during or equitably adjusted for any type of partial performance. Next, I would want to ensure that the clause requires my seller to promptly notify me that the force majeure event has occurred, as well as provide me frequent updates throughout the pendency of the event regarding the anticipated duration so that I can make plans and react to this event in order to protect my own business. Dovetailing from this, I would also want to include a right for my buyer to procure goods and services from alternate suppliers, despite any type of exclusivity provision in the contract. A clause such as this may not have provided me a lot of relief during COVID-19 because of the global nature of the crisis. But as Jen said in her presentation, many force majeure events are likely or highly localized events, such as tornadoes, hurricanes, things of this nature. So there may well be other suppliers that could perform in other geographic locations, and I would want the ability for my buyer to use those other suppliers. The next thing I would want to include in a clause for a buyer is that the seller is required to use all commercially reasonable efforts to perform to the extent they are able, including partial performance or delayed performance. If one delivery method is prevented, I would want them to use alternate delivery methods, for instance. So a seller should not just rely that the exact language of the contract may not be able to be performed as written. They should use alternate methods or alternate ways to fulfill my contract, in other words. Finally, the last thing I would draft into my buyer force majeure clause is, of course, a right to terminate the contract if the force majeure event continues for some period of time. As the buyer, I'm going to want this to be fairly short so I can quickly move to other long-term permanent solutions for my business. So I probably wouldn't want to see much longer than 30 days. So those are the types of clauses I would look to include when I'm representing the buyer. Next slide, please. So turning then to when I'm representing a seller, what do I like to see? Well, of course, a seller's concerns are the opposite of the buyer's. The seller is the party that has the performance obligations under the contract. So a seller will be concerned with having an excuse for non-performance if certain events outside of their control are to occur. Therefore, as counsel to seller, the first thing I would like to include in my force majeure clause is a statement that the buyer's payment obligation to me is not subject to force majeure. In other words, if there's an economic downturn that may affect the buyer's desire to purchase the goods or ability to pay for the goods, that would not constitute a force majeure event as long as I, as the seller who's able to perform, and willing to perform. So that's the first thing I would do, is exclude payment obligations from the definition of force majeure. Next, in drafting the clause for a seller, I would want to look again at that definition of what constitute a force majeure event to be sure it includes all of the types of events that I would likely want to rely upon or could foresee needing to rely upon if my performance is prevented. As has been discussed earlier in this presentation, I would advise my sellers not to rely on catch-all phrases like all events outside a party's reasonable control, because the courts have shown that they're likely to construe those types of clauses narrowly and maybe even to impart an unforeseeability requirement to vaguely drawn clauses. So I would want to remove from the court's hands the need to interpret the intent of the parties and expressly include in my clause all of the events I think I may need to rely upon. So this dovetails to my next point, which is that I would state that my ability to perform would be excused, of course, by the listed force majeure events, whether or not they are foreseeable. Of course, we all know now that epidemics or widespread disease are foreseeable events that should be addressed in force majeure clauses. I'll talk a little bit more about that in a minute. So turning to my next point, the next thing I would want to include is a statement that the seller will not have any liability, of course, for non-performance or delayed or partial performance, so long as the seller has met its obligation to provide the notice required by the contract. And finally, I would just want, again, an appropriate amount of time or a clause that states that the buyer has the right to terminate the contract. I would want that to be a long enough period of time that I have had some opportunity to mitigate or resolve the force majeure event so that the contract is not terminated. So again, 30 days or more here. And in closing, I just want to say I would advise both buyers and sellers to include epidemics or widespread disease in their force majeure clauses going forward, as well as perhaps acts of government. COVID-19 will now forever make epidemics a highly foreseeable event. That if it's not included in your contracts, the courts will likely presume that this was a purposeful exclusion from your provision. So I would encourage, whether you're a buyer or a seller, it's likely that this is going to impact you and that you should consider including it in your clause, your force majeure clauses going forward. So I will turn it over now to Jeff.
Thank you. I'm going to discuss the issue of force majeure from the perspective of the construction industry and contractors and owners. The first point I would make is that most construction contracts do not use the term force majeure. Industry forums do not talk in terms of force majeure, even though force majeure type events are common issues to be dealt with. Industry contracts think in terms of three types of descriptions for project delays and disruptions. So they're categorized into three groups: compensable delays, excusable delays, and not excusable delays. So an excusable delay is an event that is within the control or responsibility of the owner, and for which the contractor typically will get both time and money. So for example, if an owner creates a design change or fails to secure a site on time, those are things that give the contractor a right, if he gives proper notice, to additional time and to additional money. Second category are excusable delays. These are delays that are not within the control or the responsibility of either party. These would be unusual weather, named storms, an industry-wide strike. And this is also where typically acts of God or events of force majeure reside. So to the extent we talk in terms of force majeure in the construction industry, it would be an excusable delay. Not the fault of either party, but having an impact on completion. The traditional view is that if there is excusable delay, the contractor is entitled to an extension of time, but not additional money. Even though it may cost the contractor more to stay on a project, 2 or 3 additional months, he's not entitled to money to pay for his extended staff. He's entitled just to a time extension, and that's the typical view. The third category would be non-excusable delays. These are delays that are within the control or responsibility of the contractor. And if the contractor fails to meet the completion date, this is often a source of damages where the contractor will be responsible for either actual or liquidated damages to the owner. So if you have an event like a pandemic or an epidemic, and if it's not an excusable delay and the contractor does not complete on time, it would be non-excusable and the contractor may be subject to damages for not completing on time. So the question then becomes, is COVID-19 a trigger for excusable delay? Is it something that falls within the second category? Next slide, please. Thank you. So the answer to this question, the first place that one looks is the contract itself. There's actually 4 steps to this evaluation. Step 1 is looking at the contract itself. And what you see on the screen are 2 typical industry contracts. The industry contract that is much more common in the construction industry is the AIA contract prepared by the American Institute of Architects. This is the general condition provision. And within this provision, you can see on the left-hand side that there is a reference, and normally this is normally marked up, and I hope the version you get will be marked up. But what it says is it has a whole list of potential causes for a delay, and it talks about things like labor disputes, fire, unusual delays in delivery, but it does not list epidemic. But notice it does say unavoidable casualties or other causes beyond the contractor's control. So epidemic is not specifically listed, but unusual delays beyond the contractor's control are. A much less commonly used contract in the industry is on the right-hand side. And this is the consensus doc form. This is used, promoted by AGC, Associated General Contractors, and a lot of others. But you'll notice on this form, there is a listing of different types of delay. And if you go through that list, you will see inserted at J, about most of the way down in the first paragraph, the term epidemics is included. So on this form, which is probably used by about 10 or 15% of the industry, epidemics is called out as a specific cause of excusable delay, but the general form, more commonly used in the industry, does not include epidemics in the general form. So step 1, what does the contract say? Now we go to the next step. Next slide, please. So step 2, if we look at the general form, can you get to the point where COVID-19 would be viewed as excusable delay simply by applying the other cause beyond the contractor's control language? Is that enough? And the answer is probably not. Most courts narrowly construe these clauses in the construction industry and other industry, and through the use of the doctrine of justum generis that you heard about earlier today, the court would say, if you have not specifically listed epidemics or pandemics or something very similar, we are not going to extend other cause beyond the contractor's control to include that. So it is probably the case that if it is not listed as a specific cause of delay, it is not an excusable delay under the clause. Now, once again, we don't have any court cases telling us this for sure because we haven't had a pandemic be a cause of delay in the construction industry in any recent history. But even assuming either that COVID-19 was viewed to be another cause of delay, or we're under a specific clause that actually lists epidemics, is that enough? Is it enough to simply say COVID-19 has occurred? Does that give the contractor a right to a delay? The next step is you actually have to look at causation, and this is step 3. Did COVID-19 actually prevent performance? In Ohio, the answer is there's probably not a case where it has. In the absence of any government shutdown order, or in the absence of any situation where a local jurisdiction has said you can't work, and of course Ohio is the opposite. We've said here that it's essential infrastructure and it should go on. It is probably not the case that one can demonstrate that actual performance has been prevented. Case law says that just because your performance is made more difficult or expensive, that's not sufficient to establish excusable delay. You would have to demonstrate that you actually could not perform on the site. And in most jurisdictions, this has not been the case. Contractors have demonstrated that they can use social distancing and other safety matters. Their projects have not been shut down. It is more expensive, but they have been performing. So did it actually prevent performance? That's a difficult test right now. The fourth step is you have to demonstrate mitigation. It's not enough simply to claim a possible impact, to say that, hey, the 6-foot rule really prevents me from being able to hang drywall. We have to be too close together and it would violate the rule. Well, the answer is you have to attempt performance, try to do workarounds, figure out how you can employ safety steps and actually attempt performance. It's not enough just to say that my performance would be prevented. So to actually get to the point where in the construction industry, this would be viewed as excusable delay would probably be a significant burden to overcome unless you had specific contract language. If you did have excusable delay, though, what would the remedy be? The next slide, please. The remedy would be an extension of time and no additional compensation unless, first of all, if the extension of time is denied, the contractor would get costs to accelerate the work. If you can't get the extension, you are entitled to the cost to accelerate because you didn't get extension. Some contracts do specifically allow for compensation or limited compensation, even in the event it's excusable delay. You might get payment for your extended staff costs or no additional profit or overhead. And certainly within a guaranteed maximum price, if you demonstrate that you have to purchase additional safety equipment, wash stations, that would normally be covered, but that's within your guaranteed price. But the real question is, what if the extension period is too long? So let's say that we really did have a situation where we were shut down. A government entity said you're not essential infrastructure or an industry, you have to stop, or you can't demonstrate that you can operate a project safely, or a local governmental official will not come out and do inspections, so you're shut down. Even if there is excusable delay, you will not get an extension of time unless the shutdown is too long. Next slide, please. So the question is, what would the contractor's remedy be if the excusable delay is simply too long? And here we're going to look at some AIA provisions that discuss this issue. These are all from an AIA general conditions of an owner-contractor agreement. First of all, 14.1.1 typical provision says that the contractor can terminate if the work stoppage is for a period of 30 consecutive days or more. And this is regardless, this could be because it's force majeure or simply because the owner has shut down the project for his own purposes. But if it's because of a court order of a public authority, act of government, and the contractor at that point in time would not only get payment for all the work executed to date, his termination costs, what it would take to demobilize, he actually would get profit and overhead for the work not yet executed, look at what he would have made, and other damages, whatever may be provable. To avoid that result, an owner may decide to suspend the project. Before a contractor would terminate, the owner could suspend. and say, look, I have to stop the job right now until we can get to a safer situation or until I can figure out my financing. In that case, the contractor would get an adjustment of the contract time and money, but solely due to the suspension. What would a 30 or 60-day delay cost him? But a suspension on traditional contracts can only last so long. And what happens is on a traditional contract, and once again, I don't, this, from our original presentation, this has been cut off a little bit here. But under 14.1.2, the suspension can only go for about 120 days. If you get beyond 120 days, then once again, the contractor can terminate the project. And there's a clause missing here that you'll see in the final provision. But the contractor can terminate and get damages, as you see there. Ultimately, though, to avoid all of this, the owner may terminate for convenience, and that is what you properly see there in 14.4, in which case the contractor gets payment for the work executed, termination costs, profit and overhead for work not executed, but no other damages. So the practice tips, next slide please, that come out of all of this are from the owner's perspective and from the contractor's perspective. You have some different practice tips. From the owner's perspective, you want to limit the definition of excusable delay. And if epidemic risk is listed, you want to include a clear causation and mitigation requirements. You want to limit exposure for suspension termination damages. And for existing contracts, what you really want to do is negotiate your suspension agreement to preserve your relationships, and you really don't want to default to contract language, which may be favorably, but too harsh. From a contractor's perspective, you may want to list epidemic risk in the excusable delay clause, so it is a cause of delay, require reasonable compensation for extended excusable delay. For existing contracts, preserve client relationships by negotiating reasonable suspension agreements, and of course, you have to pay attention and observe all notice requirements for claims. You have to make sure that all notice requirements for claims preservation are in place. So with that in mind, we're now going to turn it over to Tom Mason, who's the head of our government contracts group, who will speak next about force majeure in the government contracts context.
Thank you, Jeff. And I want to make sure as I start here that when we focus on government contracts, we understand that one of the parties to the contract is a public agency. Whether it's local, state, or federal, we're talking about a government being a party. And in government contracting, we don't call it force majeure, it's called excusable delay. And I think Jeff covered that aspect of that, the different types of delay. But we're talking about excusable delay. So our focus here is on the allocation of risks. And the way that the governments do it is they apply two dispute resolution clauses. One's the Contract Disputes Act, and the other's the Contract Changes Clause. Both of these clauses are included in the contracts, and they require performance to continue while the dispute is being resolved or changes are being negotiated. And so the hallmark, I think, here is that whether we have excusable delay or we have some other cause for a failure to perform, the contractor has to use best efforts to get the job done, has to continue performance. And the other thing that I want to make sure that we understand here as we look at this very briefly is that at the federal level and at the state level, local level, there are contracting clauses that are by regulation and by statute put into contracts. And so we're not drafting clauses, we're simply looking at the clauses that have been contained in the contract, and we're making, we might have some negotiation as to what clauses would be included, but generally speaking, we're going to have the clauses that are part of the public contract. Let's look at the next slide, please. And so there are many, many different clauses that we could look at. And I'm going to focus simply on two. These are just two examples. They're not at all exhaustive of the number of clauses that could be applied. But I'm going to look first at a firm fixed price contract. It could be a cost reimbursement contract. It could be a services type contract. It could be a construction form contract. It could be any type of contract. I'm going to look at firm fixed price and show you the default clause. Generally speaking, in a government contract, you keep performing until you're terminated or the job is over. If you're terminated for default, you get no costs, no schedule relief, no costs, and oftentimes you could be held accountable for somebody else finishing the job. And so the way that the force majeure, excusable delay is dealt with in the government contract perspective is that the contractor is not held liable for acts of God, for things that are beyond the control of the contractor. And so if they're not held accountable, they cannot be terminated for default. And so under this doctrine, we see a lot of different things listed, and oftentimes the government will add other conditions, particularly if there's a wartime setting or an emergency setting that's the result of a storm. But in the general specific clause here that I've got noted here in the outline, a government action would include the acts of the government, and it would also include the government actions under a contract. In other words, that contract action would be considered as if it were an act of the sovereign, and that also then would be inclusive of different events that are covered. And under the default clause, epidemics is specifically called out. So COVID-19 would be something that's specifically called out, and as we'll see later, there are specific acts of the sovereign, of the government, that will be helpful in our determination of what steps we would take as a contractor. So again, these are not clauses that we draft, these are clauses that we agree to when we sign and execute a contract, and they're clauses that contain the specific language for excusable delay. Let's take a look at a commercial clause in the next slide. So if you're selling commercial off-the-shelf products, and we see during this pandemic, the governments have been buying all kinds of things from commercial vendors, and they've been using a commercial item form contract. It's nevertheless a government contract, and it nevertheless gives the contractor a defense if they're unable to deliver because of the events caused by the pandemic. And the contractor has a duty under the commercial item clause. It's the same duty as the other contracts, it's just spelled out a little bit differently, and that is to provide notice to the government contracting officers. And in addition with the notice, there's an obligation to say, this is how I'm going to address this problem. This is how I'm going to remedy this situation or mitigate this problem. This is how I'm going to not only accomplish the contract, but save money to the taxpayer. And also when the reason for the delay is subsided and has gone away, there's also a specific duty to notify the government of that event as well. So again, we're going to look at the sample. We've looked at a couple of sample contract clauses because in our contract that we're going to execute, we're going to take a look at these excusable delay events as they're spelled out in the various clauses. Next slide, please. So the general requirements have been spoken of before. An event must not be foreseeable. The mere possibility of something occurring is not going to constitute foreseeability. The event must be beyond the control of the contractor and also without the contractor's fault or negligence. And so the delay is not something that can be, you can't get relief under an excusable delay if you've contributed to the delay if you're a contractor or if it's an action that you should have prevented. And it does come up often that a prime contractor can't perform because of a delay of a subcontractor. The same general rule would apply if you're a prime contractor and through no fault of your own, a subcontractor was unable to perform. You did not contribute any thing to that negligent performance, something you simply couldn't provide. You still could take advantage of the excusable delay and negotiate a settlement under either the changes clause or the disputes clause. Next slide, please. Generally speaking, in government contract litigation law, we'll see that excusable delay causes are often litigated, and oftentimes it's a question of fact as to whether the fault was delay was the fault of the contractor or the fault of something that was unexpected, like the pandemic. And the likely culprits here, lack of finances, lack of equipment, lack of materials, are typically at the bottom of cases where where litigation is present, because the government will contend, well, the reason that you couldn't perform is because of your own lack of finances. You were lucky that their pandemic came along and saved you. And so this often becomes a question of fact. And we go back to the general requirements, and also under the disputes clause and the changes clause, there's a process by which you must identify the problem and take steps to mitigate it. And that often becomes the focus, not the cause or the alleged cause, but what did the contractor do to mitigate the damage, mitigate the loss, and get the contract performed. Next slide, please. So this is the most important slide I'm going to speak to. And what we speak to our clients, and also with the government, is how are we going to mitigate risk? And generally, we mitigate risk as a government contractor by having detailed work plans and having a good cost of accounts. We're able to associate costs and schedule to the work that's being done. And if we've got a good detailed work plan, and we've got a good charts of a cost, and we're capturing costs as we complete the work, and we're recording this on our schedule, we're going to be well prepared to deal with the delay. Now, in a government contract, the government can pay for the cost of insurance premiums. And so we often will take a look at getting insurance coverage to handle delay and disruption. And this insurance or reinsurance can include the cost of weather, an epidemic such as we have with COVID-19, and other identifiable risks. So generally, we have a detailed work plan, a good scheduled cost collection plan, insurance, reinsurance. And now there's two other acts that are very important to us today. One is called the PREP Act. Now, the PREP Act is an act that gives immunity to certain government contractors and subcontractors who are working primarily in the pharmaceutical field, and they're providing drugs and remedies. And to the extent that they're injured or damaged or delayed, that act gives that contractor some protection. And finally, Public Law 85-804. I'm just going to speak briefly about this. This is part of the risk mitigation plan. And the date to remember is April the 10th, 2020, because that's the day that President Trump put into effect Public Law 85-804. And this is an act that indemnifies any public contractor from any loss that is a direct consequence of the pandemic. And so if I'm taking a look at the performance of a contract, then I want to make sure that it's performed and performance continues, and all the claims are being paid, and payments can be made to subcontractors. I'm going to take a particular hard look at my risk mitigation plan, and I'm going to take a look to make sure that not only we have the excusable delay clauses in the contract, but we've got all these risk mitigation procedures that are in place. And so from a government perspective, that's a brief summary of what we look for. And I'll turn it over to Tom. He's going to talk from a business litigation, and as mentioned before, he's also our firm loss prevention partner. So Tom, over to you.
Thank you, Tom. I'm going to speak briefly about what are generally referred to as material adverse change or material adverse event clauses. Matt, 2 slides, please. These are clauses that appear in many merger or asset purchase agreements that might allow a buyer to cancel a deal if an event like a worldwide pandemic, for example, causes significant deterioration in the target business that threatens the economic fundamentals of the deal. Matt, slide, please. One more. Thank you. This slide shows the form language. Go ahead. Sorry, Matt, one more. Shows the form language for such a clause from the American Bar Association. It says that material adverse change means any event, change, development, or occurrence that is or could reasonably be expected to be materially adverse to the seller, the business, or their financial condition, assets, results, or prospects, or to the seller's ability to perform. So just like the other clauses we discussed today, these clauses are risk assignment tools. They are designed to say which party takes which risk of potential changes in the economics of the deal. In light of the fact that almost every business in the world besides maybe Amazon has either shut down or had its sales drastically cut, it's pretty fair to say that the economics of most pending deals out there have changed dramatically. So these clauses are now in the spotlight, and they've been raised as key issues in disputes around the country where buyers are trying to get out of or renegotiate pre-pandemic deals. Many deals have already been renegotiated where the threat of invoking these clauses and the buyer's ability to perform were at play. Others yet have landed in court when those negotiations failed. In most of those cases, sellers are asking courts to declare that the pandemic doesn't give the buyer an excuse to get out of the deal. Suits have been filed all over the country, and I'd say this disproportionate number of them seem to be in the energy and hospitality spaces so far. Several of the deals landing in court are notable, including SoftBank's deal for WeWorks and the purchase of Victoria's Secret by Sycamore Partners. Another of the more notable suits was brought by Bed Bath & Beyond, seeking to enforce its deal to be purchased by 1-800-Flowers. Apparently, 1-800-Flowers has indicated that the pandemic excuses it from closing the deal. Bed Bath says that the adverse effect clause in their deal was a bit more expansive. Matt, could you click that one more time? They say that in their clause, in their deal document, industry-wide or market-wide effects stemming from general business, financial, or economic conditions, including any resulting from calamity or acts of God, would not excuse performance of the purchase because they would not constitute material adverse changes. So though that's not part of the form ABA language we looked at, that kind of exception language is common. Matt? Still, other clauses will also include language saying that material adverse changes will not include general economic events, changes in law or regulatory policies, changes in GAAP, acts of war or terrorism, or changes in market or interest rates. Matt, one more. Still others will go a little further and provide exceptions to the exceptions, as lawyers want to do. These can say that the economic changes can be material adverse effects if the general change has a materially disproportionate adverse effect on the target, at least relative to the others in the industry, or in its industry. So if the parties end up in court, what does a purchaser need to show in order to use a material adverse change clause to get out of the deal? First and foremost is to remember that these cases, unlike some of the earlier things we heard about earlier, are not based on a uniform standard in the law like the UCC impossibility standard. So at least as a dispute settled by the courts, the language of the deal document is likely to be the biggest factor at play. The success of the claims will vary because the language at issue will vary. Matt? One more. In the prior reported cases addressing material adverse change clauses, there are several key points the courts will consider, including whether the change really adversely affects the fundamental economics of the agreement and whether the adverse event changes the financial aspects of the deal in what's called a durationally significant manner. The courts say that the event has to be something that will have a years-long effect on the business. Short-term hiccups do not suffice. Of course, as we sit here today, we have no idea whether the effect of the current crisis will be more of a hiccup or more of a death knell for any particular business. Matt, one more. The courts have also looked at the issue of foreseeability, just like in the force majeure clauses. Was the event within the contemplation of the parties? Was it within the control of one of the parties to avoid? And what is the magnitude of the impact on the business? Was the magnitude of the impact beyond what the parties contemplated? These principles, including the emphasis on the years-long effect, have traditionally been viewed as a pretty high standard to be met by anybody seeking to invoke one of these clauses. Courts have generally not been in favor of terminating deals, and in fact, there's only one reported case ever in Delaware where a court found that the standard was met and the buyer could get out. Early in the pandemic, this prompted most commentators to say it's an almost impossibly uphill battle to invoke these clauses and get out of deals. Many noted that on the issue of foreseeability, we had big economic crashes in 2001 and again in 2008, and we've also had global health crises like SARS and the bird flu that have devastated large economies before. But this shutdown of an entire economy in less than a week doesn't seem to look like anything else before, not 9/11, not 2008, and not SARS. So I think that view might be changing. And one can certainly imagine that there might be a sympathetic judge out there that sees this situation as wholly different and an unforeseeable event. In talking about future outcomes, it's also important to note that the material adverse effect clause may well not be the only part of the deal implicated by the pandemic. While in a number of the cases filed so far, the seller has focused on the applicability of the clause, the buyers are making additional arguments. Many of them have claimed that closing is excused not because of the effect of the pandemic under the material adverse effect clause, but because of how the seller responded to the pandemic. The Victoria's Secret case we talked about earlier has now reportedly settled. And the press report suggests that the buyer was allowed to walk away, even though there was a real question about whether it could rely on the material adverse effect clause to get out. But there, it appears that the buyer claimed that Victoria's Secret breached certain other terms of the deal by closing stores, laying off workers, and depleting stock in response to the pandemic. That position was rooted in other language in the agreement. And similar arguments have been made in a number of the other cases that have been filed so far. So again, the language of the document, not just in the material adverse effect clause, but elsewhere in the document will make the biggest difference when things head to court. So for anyone involved in negotiating deals now, this emphasis on the agreement's express terms is of course important for everyone to remember. Many folks at our firm and around the country are already involved in negotiating deals where these clauses are at issue, and the parameters of what effect the pandemic will have on the deal are trying to be defined. The final contract language will define the ability for any party to use it as an outcard in the future. Anyone wishing to allow for or prevent current or future pandemics from creating a deal obviously has to consider how to write these clauses differently going forward. Matt, can you hit this 3 times? Going forward, it will be very difficult for anybody to claim that pandemic-based problems weren't foreseeable. And the more express language in the contract, the more likely it will be to be effective. So anyone desiring to allow or to exclude a pandemic as a basis for taking a deal signed after March of this year had better say so directly in their document and address it full on. So that's what I've got. We're about out of time for me. Thank you for listening. Matt, back to you.
Thanks, Tom. We do have a question that I wanted to address while we have a few moments here at the end of the presentation. And the question was, once the governor's order is lifted, does the force majeure provision still apply? That is, events scheduled for the fall. And my perspective on that is the question of whether or not the force majeure provision would apply to events scheduled for the fall would depend on the language of the agreement itself and whether or not the epidemic is still preventing performance or otherwise disrupting performance in the fall. And this goes back to one of the analyses that Jeff did in his presentation, is specifically related to construction, but it's equally applicable to other industries as well, is that does the language of the agreement cover this type of event, a COVID-19 pandemic? And if the answer to that question is yes, is performance being prevented by the pandemic at the time that the event is going to occur? So right now, the answer to that question and many times is yes, because the governor's order has ordered the retail shops to close or otherwise order businesses to shut down. Whether that remains true in the fall, even after the governor's order is lifted, is something that is going to have to be addressed at that time, and we can't predict. If you are seeking CLE for today's program, the tracking code is TH0512. Again, the tracking code is TH0512. If you have any additional questions after today's webinar, feel free to email or call your current Thompson Hine lawyer, who will direct you to a member of our COVID-19 task force. If you're not a current Thompson Hine client, please contact one of us and we can discuss with you options to address your needs. Again, if you're seeking CLE for today's program, the tracking code is TH0512. Again, the tracking code is TH0512. If you're not currently receiving our updates and invitations, we invite you to go to the Thompson Hine website and register to receive our mailings under the Publications tab. Thank you all for your interest.